Hi, and welcome back to Mr. Raymond's Social Studies Academy for an AP Government exam review on the Judicial Branch. And this one is going out to some more of my former APGov Hall of Famers. I hope you guys are doing well. So this is an overview of the Judicial Branch, mostly focused on the U.S. Supreme Court and their interactions with the other branches, as well as the impact on governmental policy. Which brings us to our first benchmark, where you will need to explain how the Constitution designed the Supreme Court to be independent, and how the use of judicial review has been a powerful tool of the court for most of its history. So what does the Constitution's Article 3 say about the judicial branch? Well, this brief section created a U.S. Supreme Court and gave Congress the power to create what they refer to as inferior courts. And this created our federal court system below the U.S. Supreme Court. The Constitution gave Supreme Court justices a lifetime tenure, which has made their appointments a powerful way for presidents to leave their legacy, as justices will often serve much longer than a president's term. Most of the framers wanted the court to be politically insulated, a concept we will come back to a few times, by being appointed rather than elected, which some would point to as falling under the elite model of representation. And these lifetime terms were meant to protect justices from political pressures. But lifetime tenure and the fact that they were appointed rather than elected were the topic of an attack by anti-federalist Brutus, which led Alexander Hamilton to defend the Constitution's provisions on the court in your last must-know of the Federalist Papers, this one being Federalist number 78. Hamilton defended that the judicial branch would be the quote-unquote least dangerous, because without the power of the purse, or controlling governmental funds, that Congress has, or the power of the sword that the executive has, this branch would be the least possible of taking away the people's liberties. Hamilton went on in Fed 78 to say that these justices needed to serve for life, to give them independence from the other two branches. And he talked about judicial review being a necessary check on the legislative power of Congress, who might pass laws that were unconstitutional. The problem was that judicial review was not a power listed in the Constitution in Article 3, and it would take your must-know landmark Supreme Court case, MARBURY versus MADISON, to establish or confirm the power of judicial review. And this, again, is the court's ability to strike down laws or governmental actions as unconstitutional, thus making them null and void. Now, details of the case are not that important for your exam, and you might have already covered it in APUSH and hopefully in this class, but it's important to remember that this case and judicial review provides the court's major check on the other two branches. So quickly, some other ways that the court can be immune from political pressure is their ability to control what cases they will hear. While an average of about 8,000 cases a year are appealed to the U.S. Supreme Court, they choose to hear only about an average of 100 to rule on. Now, a major aspect that the court has in influencing and establishing policy is their creation of what are known as legal precedents. In their rulings, they impact all future court decisions, a concept known as common law, and can establish new guidelines not only for future cases, but also federal and state laws and governmental procedures. And again, these are called precedents. Now, it's important to remember that the U.S. Supreme Court, for the most part, rarely overturns laws as unconstitutional. But when they do, it can have huge ramifications for the nation. And this brings us to our two philosophies about the court's role in shaping policy and law: judicial activism versus judicial restraint. And the names are kind of a giveaway. When we refer to a court as employing judicial activism, it is one that will more frequently use judicial review, their decisions and opinions, to establish new policies or override laws. And this brings up some contention as, is it really the role of these unelected justices to shape policies or laws passed by our elected representatives? Well, one of the most famous activist courts is referred to as the Warren Court, after Chief Justice Earl Warren. And we will be reviewing many of their landmark decisions in our upcoming lecture, Brown versus Board of Ed, which established the precedent that legal segregation was unconstitutional, Gideon versus Wainwright, which forced states to provide lawyers free of charge, and Miranda versus Arizona, establishing rules for police interrogation. So you can see why this was considered one of the most judicially activist courts in U.S. history. Now, while the Warren Court is referred to as one of the most liberal courts in U.S. history, the Rehnquist Court from 1986 to 2005 was also very active in establishing precedents, albeit in a more conservative way, a tradition that continues under the Roberts Court today. Now, conservatives are not very often associated with the activist label, and some argue that these courts have been trying to reverse the activist policies of previous courts, which leads to our other philosophy, judicial restraint. Now, this is the concept that judges should leave policy matters to the other branches and respect what is called stare decisis. Stare decisis, which roughly translates to let the decision stand, is the concept that judges should abide by precedents set by other courts and limit their own interpretations, leaving the policy and lawmaking up to the other branches of government. Alright, so let's wrap up by looking quickly at the checks on judicial power, always an important aspect of your AP exam. And let's start by looking at the relationship between the executive branch and the courts. Remember, Hamilton and Fed 78 referred to how the executive had the power of the sword and not the judicial branch. And this leads to the often contentious debate, is the president required to enforce judicial decisions that they disagree with? Or can they just choose not to do so? President Jackson certainly thought so way back in 1832. Jackson famously said, referring to the Chief Justice at the time, "Marshall has made his decision, now let him enforce it." The main constitutional check, however, that the president has over the court is their power to appoint judges and justices, who, as we mentioned, can influence public policy well after a president is gone. This brings us to the court and Congress. We talked about judicial review. So what can Congress do if the court finds its laws unconstitutional? Well, they can rewrite a law in a way that addresses the parts that were found unconstitutional, hopefully taking those out, and pass a similar law. And as we've talked about multiple times, the Senate must also confirm presidential appointments to the court, and this has increasingly become a political debate, as it's a major check on the direction that the court will take. Now, in an extreme case, if the court finds a law or practice unconstitutional, Congress, with the help of the states, can pass an amendment, thereby adding it to the Constitution, but this is very rare. So speaking of the states, they too can attempt to avoid or ignore judicial decisions and precedents, as happened after the Brown versus Board of Education case, forcing the Supreme Court to issue another ruling in what is often referred to as Brown Part 2, telling the states to hurry up and integrate their schools. And that leads us to part with this. Many continue to debate the power of the Supreme Court and whether it has become too partisan. Is this what Brutus feared? The debate over the power of the Supreme Court and the judicial branch will continue into the future, especially in our highly partisan state, and will play a role in our upcoming video on civil liberties and civil rights. But until then, thanks for watching, guys, and get ready to ace that exam.